In today's video, we're going to be talking about what it means in the District of Columbia when a criminal case is no-papered. We get a lot of calls and contacts off the web from folks who were arrested. Maybe they were held overnight in jail, or they were given a citation to return to court. Whatever it is, they show up at court and they're told by a judge or a judge or a clerk that their case has been no-papered. My name is Joseph Scrofano. I'm the founder and managing partner of Scrofano Law PC, where we fight relentlessly on behalf of anyone in trouble who cares about their future. We specialize in defending criminal cases and investigations in the District of Columbia, Northern Virginia, and Southern Maryland. So, to give you an understanding of what it means from a legal standpoint when a case is no-papered in DC, I'm going to talk a little bit about the prosecution process. In the District of Columbia, there are two main prosecuting agencies. There is the United States Attorney's Office for the District of Columbia that has jurisdiction over most misdemeanor cases and all felonies. And then there's the local prosecuting agency, the Office of Attorney General for the District of Columbia, where they only have jurisdiction to prosecute traffic crimes like DUI, reckless driving, stuff like that. Either way, the process for papering is considered the same. So to understand the papering process, you kind of have to go behind the scenes in how it works when someone gets arrested. When an individual is arrested, the police are going to generate a bunch of paperwork, body-worn camera video, witness statements, whatever it is. There's going to be a lot of paperwork that gets filled out, and that paperwork is going to get transmitted to a specific designated prosecutor on any given day who is responsible for papering that day. They call that the papering prosecutor. And that prosecutor is going to go through the police paperwork, and whatever information is submitted by the arresting officer and arresting police agency, and then make a determination on a case-by-case basis whether the government wants to actually file charges against the person who was arrested. Now, if you go to court and you're told your case is no-papered, that means that the prosecuting agency, the specific papering prosecutor that day, made a determination that the government was not going to file charges against you. So you have been arrested, but you were not charged with a crime. And it's important to understand that if you're filling out applications down the road, could be for security clearance, for grad school, or whatever it is, you may get asked a question on an application. Have you ever been arrested? Have you ever been charged with a crime? Have you ever been convicted of a crime? If your case was no-papered, you could truthfully say, no, you've never been charged, and no, you've never been convicted, but you still have to say that you were arrested. Now, why would a prosecutor no-paper a case? There are lots of reasons why it happens. Sometimes the police screw up the paperwork. Sometimes the prosecutor may look at what the officer alleges happened and see that just on the face of things that there's no probable cause for the offense. Or maybe in some rare instance, a prosecutor might look at a case and think that the police officer might have violated someone's constitutional rights, and so they decide not to file a charge. There's really no way to find out why. That's not a piece of information that the prosecutors or in the U.S. Attorney's Office or the Office of Attorney General are going to share with you. The main thing you need to understand is that you don't have any obligations to the court. You're not going to be charged. You're not going to be convicted. You're not going to be going to jail or put on probation. Now, theoretically, from a legal standpoint, a prosecutor could legally refile the charges at a later date. Now, that is an extremely rare situation. In most cases, when someone's arrest gets no-papered, that's pretty much the last they're going to hear of it. The last thing I want to point out is that you may be eligible to have your record sealed, your arrest record sealed. As I mentioned before, you have not been charged with a crime, you've not been convicted of a crime, but you do have an arrest. And that arrest is going to be on your record and follow you around unless and until you get it sealed up. And if you've been to court and you've been told that your case has been no-papered, I highly recommend that you contact us. We have filed dozens, if not hundreds, of expungement motions on behalf of our clients over the years, and we can give you a free consultation and explain to you if or how you may be eligible to have that arrest record sealed.